Good evening, and welcome on into part 2 of today's from day 1. Sorry, I just thought of something to put in that spot. Okay. As always, we grab the mailbag to begin. So let's go ahead and do that real quick. Alrighty. As we had left last night, we will pick up the moron, whatever you wish to refer to him as, in court with the judge. After that, I don't know if we will stick with that or we'll go with some of the newer content that some of my friends have sent to us today for part 2, but at least to begin, let's finish out that Moore case. Go ahead, Judge.
Of concern to the court today and always, and under the line of cases of Brasati, Reddish, and most recently, State of New Jersey versus Pascal Dubois, at 189 New Jersey 454, is whether a litigant knowingly and intelligently waives the right to be represented by counsel when he or she says to the court, I don't want a lawyer.
Objection. I already stated for the record that the Aboriginal law firm has power of attorney over Cheyenne Matilda Cushman.
The inquiry that the court must make.
I love that she basically 100% ignored them there.
Deals with certain requirements set out in Brasati. And it really comes down to whether the defendant understands the nature of the charges, the range of punishment, the technical problems associated with self-representation, whether the person is able to understand the rules of procedure and evidence and understands that he or she will be required to comply with them, whether the person understands the lack of legal knowledge of the law, the procedure will impair the defense, whether the defendant understands and appreciates the impact and the danger and the pitfalls of appearing in the dual role of a defendant and an attorney, whether the person understands how unwise it is to proceed without assistance from an attorney.
No objection.
I have attempted this afternoon, and the last time this matter was before the court, to obtain from Mr. Cushman answers to the questions.
I'm not a mister.
And find out.
Oh, go fuck a sucking egg here. You're gonna argue now on a frickin' pronoun?
Whether he understands. That's right.
So you're threatening me?
What about the 26th? Are you available then?
Are you threatening me now?
Of course I'm not threatening you.
So,
Mr. Cheyenne Matuda Cushman, you should be clear in your mind that I am issuing no threats to you. As I said before, you've been exceedingly polite and courteous. I think I've been polite and courteous, despite the goading that goes on. However, these are the dates that I have. Monday, January 5th, Monday, January 12th, Tuesday, the 20th, and Monday, the 26th. Any of those days better than another for you?
I'm not subject to the court's jurisdiction, so I will not be able to physically attend any of the court hearings.
Well, appear metaphysically then. Monday, January 26th at 9 o'clock in the morning.
I cannot make that date, man.
Oh, you know what? I can't either. We'll come back for the 20th.
Under threat, duress, and coercion, I choose Tuesday.
You want Tuesday the 20th?
Under threat, duress, and coercion.
Tuesday the 20th at 9 a.m. If you're not able to be here physically, you can be here metaphysically. What we will decide on that day is we will do the briefing schedule so that we can decide the issue of jurisdiction.
Okay, can you clarify, what do you mean metaphysically?
I don't know. What do you mean you can't be here physically?
I can't be here physically in this room. That's
Okay.
what I mean.
Okay.
Can you clarify?
No, I cannot, and I will not. On that day, we will set the briefing schedule so that the issue of does this court have jurisdiction can be heard and determined. All right?
Agreed.
Pardon me?
Agreed.
So all the briefs that I have, we will collect. If we need others, we'll tell you when they're due, and I'll give a hearing date. That's the issue that will be decided on that day. Now, I know in this particular case, there is another person who is named in the indictment. The name on the indictment, and I understand you're going to say object because that's nobody's name. I understand all that. Is Cornell Dixon, also known as...
Objection.
No. Let me just read this. Cornell Dixon, also known as Colonel Chauncey L., also known as Cornell Hall. I am unable at this time. I know that the Moorish American Aboriginal Indigenous Sovereign man who goes by an attribute different than that, which I cannot remember now, I apologize. I think it's Amir Purnell CL, but I don't have the whole correct attribute written down. Amir Colonel Chauncey L. His matter will also be scheduled for the same date and time. Separate notice will be sent on that case. I'm not expecting you to do anything with that, but that will be it. Now, I do not know if Amir Colonel Chauncey L. has also raised the issue of jurisdiction, mostly because I don't remember.
Judge,
if he has...
I don't know if he's raised the issue of jurisdiction. I know he's represented by Mr. Keith.
Objection. Mr. Keesler has no contracts with any member of the America Society.
You are unable to speak for Amir Colonel Chauncey
L. is a member of the America Society, and I'm able to speak on his behalf because that is the law. He is a member of my society, and he does not have any contracts with any public defender, John Keesler.
Well, all I know is Judge Smith appointed the Office of the Public Defender.
Objection.
Represent Amir Colonel Chauncey L. And I understand that the Office of the Public Defender assigned it to Mr. Keesler.
Objection, ma'am.
Whether you object or you don't object, that's the status. What I wanted to advise you of this is I do not know if in the proceedings involving him, the issue of jurisdiction has been raised. We will discuss that on the 20th as well. I assume he's raising the same issue. Has that issue been raised, Mr. Luciano?
Judge, I will say I think the papers have been filed together.
Okay.
Both in defense.
So that issue has been raised.
I think it's probably fair to
And with regard, then you should be prepared with regard to that we will address that as well.
Yes, ma'am.
Yes, Amir Colonel Chauncey L., member of the America Society, has raised jurisdictional questions as well.
All right. And we'll deal with those then.
And you said this is January 20th?
It's Tuesday, January 20th at 9 a.m. here in this courtroom.
9 a.m.
Yes, sir. And again, in addition to whatever else we have to do in this case on that day, we will set a briefing schedule and a hearing schedule so that the issue of jurisdiction can be determined. Because as I told you before, I don't know if you listened.
No, he didn't.
I acknowledge that you raised that issue, and I acknowledge it has to be decided. Mr. Luciano will be prepared to address that issue as well. Because the way it happens in these cases, and I'm telling you, you're not a lawyer, but in any event is, you raise the issue, you present whatever law, whatever facts you have, Mr. Luciano gets to respond, we have a hearing, there can be oral arguments, sometimes there isn't, and then I decide if the court has jurisdiction.
Objection, ma'am. I am a lawyer of my society, the America Society, and
Anything else in this matter before for me?
no, ma'am.
Now, you did have some papers that you showed me and you gave them back to you because it looked like that might be your only copy. Are you filing them with the clerk of the court?
They've already been filed with the clerk of court.
Can I just tell you something?
Yes, ma'am.
You are filing things that you want me to see. You want me to see them sooner rather than later. When you file them downstairs, put a little, do you just post a little post that says, please deliver this to Judge LeBon's chambers, or you don't even have to say please, not to be polite, although you are exceedingly polite. Put on there, deliver to Judge LeBon's chambers, because what happens is when you file them downstairs, they simply go into the court file, and unless I come in on a Friday morning and say to myself, gee, I ought to go downstairs and see if there's anything in the file that has indictment number 441, I wouldn't see it until, like today, I called the file up. So it makes it easier for everybody.
Problem.
Anything else? Thank you very much. Court is in recess.
Court wants you to leave.
Do you want to take your green sheet with you that has the court date on it?
No.
You know, we always give them to you, and you always say, no, I'm not going to take it. I forget what you write on there.
I have the date here now.
Okay, very good.
All right. Have a beautiful day.
Well, Your Honor, he always writes that he's an idiot on there. And I guess we will stay with this because he's back. Same guy. So we will continue with him just because of that.
All right, good morning. This is under indictment 08-04-0441. Counsel, your appearance, please.
Judge Anthony, Assistant Prosecutor Michael Luciano from the state.
And Cheyenne M. Cushing-Murrell, would you state your name for the record, please? Your attribute for the record, please.
Cheyenne M. Cushing-Murrell on behalf of America's Empire Aboriginal Law.
All right. I want to ask you a couple of questions, please. The first question I want to ask you is, are you employed?
Objection, man. This hearing is supposed to be about jurisdiction. The court has no jurisdiction. The court has no jurisdiction to determine its own jurisdiction for a basic issue in any case before trial.
Well, if I have no jurisdiction to determine my own jurisdiction, how are you going to get that issue resolved?
Listen, this case in this courtroom is a culpable, incompetent court of jurisdiction. You can't, according to federal case law, you can't set another hearing to reach and determine your own jurisdiction. As I've stated for the record plenty of times, I'm only handling threat, duress, and coercion, and because the prosecution falsely holds my property, and I'm here to clarify that matter. Other than that, I'm here under threat, duress, and coercion. It is completely against federal case law. It has power to act, and the court must have the authority to decide that question in the first instance. That's Rescue versus Municipal Court of Los Angeles. A departure by a court from the recognized and established requirements of law, however close apparent adherence to mere form and method of prestige, which has the effect of depriving one of a constitutional right, is an excess of jurisdiction.
May I interrupt you for a moment?
You may not, ma'am. Objection.
You don't tell the judge that they can't interrupt.
So that I can ask a question?
I'm not obligated to answer any questions, so I have no intentions of answering any question.
I'll ask it anyway, and you can decide what you want to say.
Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term, Dillon versus Dillon. Courts enforcing mere statutes, as it is to my understanding, that this is a statute and not a constitutional violation of law. In fact, one of the hearings I had with you, you said people are not charged with constitutional violations. I don't understand how you can be enforcing statutes when you have the Constitution, the U.S. flag behind you, as if you hadn't taken the oath to uphold the Constitution. Courts enforcing their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. Boswell prosecution doesn't even have folders in front of him. He has no objections. He has nothing to say. He cannot prove jurisdiction. This court should have been dismissed this case. This is a colorable court with competent jurisdiction. The fact that petitioner was released on a promise to appear before a magistrate for an arraignment, that fact is circumstance to be considered in determining whether the first instance there was a probable cause for the arrest. Monroe versus Papa. There is no
Did we lose connection with you, dear sir? Granted, I was getting bored of the idiot's diatribe, but...
discretion to ignore the lack of jurisdiction. Court must prove on record all jurisdiction facts related to the jurisdiction asserted. A universal principle is all.
Alright, we're going to give it a few seconds, I guess, to buffer. And try to get it ahead. We've actually ran into a couple great battles, and heck, we might actually have another one. Let's go for it. To get into the top 200, probably for the first time ever. Granted, it's going to be a little bit hard with a blocking 117 Aurora and then a Dante. We will give it a whirl. So I guess it's going to be our first crack in a long time to get inside the top 200 here. Oh. Come on. Come on, stay in there. Stay in there. Ah. We actually had a shot at least. Which is more than I gave myself credit for going into that battle. And the 247 at least is enough to best our best record we've had by 10 spots. Alright, I think we have connection with the case again. Let's try.
As the law is that proceedings of a court without jurisdiction are a nullity and its judgment there without effect either on person or property. This case has already been put before the federal court and you will be receiving a notice of removal very shortly. This court has no jurisdiction. Prosecution can't prove jurisdiction. This case shall be dismissed and it will.
Did you file a notice of removal with the federal court?
Yes, you will be receiving it shortly.
All right. When I receive it, I will rule on it. This is my question to you, however. Are you employed?
I'm not employed. I'm not employed with any corporations incorporated with the state of New Jersey.
Are you employed with any corporation that's incorporated outside of the state?
Objection. I'm not here to answer questions about my employment. The last time I was made aware of this was supposed to be about whether this court has jurisdiction, and clearly it doesn't. A question about employment has nothing to do with whether this court has jurisdiction, so I'm not obligated to answer those questions. I shall not be answering any more of those questions that are not pertaining to jurisdictional facts.
Well, this is my question to you. I asked it before. If your position is that this court has no jurisdiction to determine its own jurisdiction...
That's the objection, man. That is not my ruling. That is not my holding. I've given you the federal case law regarding such. Maybe you can take some time out that you need to do to recheck that, but that's what the case law says, not what I said.
Well, I do have jurisdiction over you. Number one, you're here in my courtroom.
Thank you, Your Honor.
Exactly. If you truly thought the court didn't have jurisdiction over you, then you would never have shown up to court, let alone shown up to court repeatedly, court date after court date after court date. You would have never gotten up out of your bed if you truly believed in your mind that the courts didn't have jurisdiction over you.
Well, I do have jurisdiction over you. Number one, you're here in my courtroom. Well, I do have jurisdiction over you. Number one, you're here in my courtroom. Well, I do have jurisdiction over you. Number one, you're here in my courtroom.
Objection, ma'am. You do not have jurisdiction over me. I'm here by way of threat, duress, and coercion. The federal case law stipulates already that compelled appearance and arrest warrants doesn't give a minister acting ministerially and not judicially enforcing mere statute jurisdiction. That's incorrect and false. You do not have jurisdiction because I'm here. You told me before when I was here that you would lock me up if I didn't come, which was threat, duress, and coercion.
I think that you misstate what I told you.
Objection, ma'am. I have not misstated. I have the videos. I have it on repeat, 24/7. I've seen you say it.
I don't recall that I said I would lock you up.
Oh, well, objection, ma'am. That's on the record.
Well, you can object all that you want, sir. And I will continue to have a difference of opinion about that. All right. Well, we'll continue with today's proceedings then. And I certainly appreciate the courtesy that you extend to me.
Yeah,
Right, Mr. Walker, I know that you are here.
Yes.
You wish to be heard, sir?
Your Honor, I have Kevin Walker here on behalf of the Office of the Public Defender. We did receive after the last hearing a court order directing the Office of the Public Defender to represent this defendant. I did file a motion for reconsideration, noting that there has been no indigency determination, which is an essential component of our appointment. So I would ask respectfully that an indigency determination be made at this time, and that's earlier court direction to represent this defendant be vacated.
All right, thank you. Do you wish to be heard on the issue, Mr. Luciano?
I'll just
All right. I have inquired of Cheyenne Mutada Cushing-Murrell concerning his employment. He tells me he is not employed in the state of New Jersey by any corporation, and therefore I determine that he does not have the present ability to pay for counsel to proceed in this matter.
Objection, ma'am. I don't know this gentleman. I haven't made any contracts with the Public Defender's Office. I don't know what that was an attempt to do, but he does not have the authority to speak for me. So I would appreciate it if any non-identified parties determining to act on my behalf first fill out IRS Form 56 and notify the IRS that they're acting in some sort of fiduciary capacity.
All right. Let's talk about the issue of, Mr. Walker, I want to talk about the issue of jurisdiction. One of the issues that has been raised in this case and has been raised over and over again that really needs to be determined before we can proceed with it is with regard to jurisdiction. I have received, it was filed with the court, it was received in my chambers on January 7th. I'm not exactly sure if it was filed downstairs on a different day. Something that has been entitled a non-negotiable affidavit of fact to dismiss with prejudice for lack of personam jurisdiction, lack of discovery, and lack of an injured party. It purports to raise the issue before the court of lack of jurisdiction with regard to Cheyenne Mutada Cushing-Murrell. Despite what Cheyenne Mutada Cushing-Murrell says, this is not an application to the court to dismiss anything with anything. There are certain ways, as you are aware, Mr. Walker, to bring issues before the court. What we need to do is have the issue brought before the court properly by way of a notice of motion. I don't even know if Mr. Luciano got a copy of this, but certainly you know that any motion filed has to be served on the prosecutor. How much time does your office need in order to do that? And did you receive a copy of this?
As I have not received a copy of that, and before I address that issue, I will respectfully request that you inquire into this defendant's assets to see whether he has a present ability to retain private counsel.
I love that. The Public Defender's Office is trying tooth and freaking nail not to be appointed. They don't want the hassle.
Tells me he isn't employed by a corporation, so.
Okay, so the man that just spoke is a legal aid, or what else is known as a public defender, a court-appointed attorney, free of charge. He is representing this Morris Sovereign, and this Morris Sovereign, from the jump, doesn't want him to represent him. Now, what the man in layman's terms, just asked the judge was to determine whether or not this more sovereign can afford to pay for his own attorney, because obviously this court-appointed attorney, this legal aid, doesn't want to represent this more.
No, he doesn't.
Because this more sovereign is way too difficult. These people are ridiculous. Even the free court-appointed attorneys, the legal aides, the public defenders want to stay far away from these moral sovereigns and their nonsense.
Before I address that issue, I would respectfully request that you inquire into this defendant's assets to see whether he has a present ability to retain private counsel.
Tells me he isn't employed by a corporation, so.
Objection. This is obscene.
Sir, this is a conversation that I'm having with Mr. Walker, not with you.
This is
And
he
the
cannot
way you
speak
didn't
for
want
me,
me
man.
to interrupt you, I would like you not to interrupt me or Mr. Walker.
Objection. This man cannot speak for me, man. I haven't filled out any public defender's applications nor contracts to agree to that. You cannot force me against my consent to have someone who I have no formal contract or agreement with to speak on my behalf. I'm a natural flesh and blood man. I don't have to have, yes, ma'am.
This judge is hilarious. This man just said, I'm flesh and blood man. And the judge was like, you are? This more sovereign doesn't even realize that the judge was just being sarcastic.
I haven't filled out any public defender's applications nor contracts to agree to that. You cannot force me against my consent to have someone who I have no formal contract or agreement with to speak on my behalf. I'm a natural flesh and blood man. I don't have to have, yes, ma'am. I do not have to have an attorney at law, a colorable attorney at law, de facto attorney at law, propose or purport to speak for me in any regards to these matters at hand.
When you asked me not to interrupt you, I didn't interrupt you. I'm asking you not to interrupt me. I would appreciate it if you would not interrupt me. Well, I've inquired of him. He tells me he's not employed.
Judge, I think he indicated he's not employed by a corporation in the state of New Jersey. I would respectfully request that your honor ask him whether he has any employment at all.
Do you have any employment at all, Cheyenne Mutata Krishamiriel?
Objection, ma'am. I'm not here to answer questions from a third-party perspective from a de facto attorney at law. However, for the record, my job in service to man is to uplift fallen humanity. That is my job.
Do you receive compensation for uplifting fallen humanity?
My job is to uplift fallen
Do you
humanity.
receive any compensation for
Only the compensation of goodwill that I receive from
uplifting
God.
fallen humanity? All right. So I take it that you don't receive any money for that. Do you have any bank accounts, stocks and bonds, things of that nature?
Objection, ma'am. I'm not going to be answering any of these questions as they're unintelligible and they have nothing to do pertaining to jurisdiction. As it was told,
Unintelligible. Which of the words did you not understand, sir?
I don't understand the entire proceeding. This is colorable and foreign to me. I'm from a different society. We're not used to these proceedings. It's colorable proceedings. And
You can say to me over and over that you do not understand and that it is not intelligible, and I do not believe you.
Well, it doesn't matter if you believe me, ma'am. I don't
completely.
understand any of these proceedings. I don't understand the questions and the nature thereof. They don't have anything to do with jurisdiction. Jurisdiction hasn't been proven, which this was supposed to be a hearing about jurisdiction.
But no one filed an application with this court for the court to determine the issue of
That
jurisdiction.
notice
A non-negotiable affidavit of fact to dismiss with prejudice for lack of personal jurisdiction is not an application to this court to take any action whatsoever.
Objection, ma'am. Haynes versus Kenner, 404 U.S. already stipulates that you must accept that affidavit as it is a written form of communication regarding the matters discussed. Haynes versus Kennedy, maybe you need to check that out. But either way, you're supposed to accept that as an unorthodox affidavit of fact.
Well, I don't know what a non-negotiable affidavit of fact is.
You don't know, excuse me.
I don't know what a non-negotiable.
The
affidavit of fact.
I have negotiable there. I don't know what you have there, man.
Take a
I
look
want
at
to
it.
see it. I have one right
I like
here.
that, a non-negotiable.
Objection. I will not choose to see that. I have a copy right here. Mine
No, you
says
can have anything you
I
want. I
love-
want you to look at what I have there. Just point out the word to him, please, and then bring it back. You gonna look at it, sir?
objection, ma'am. I've already stated that I will not be looking at it. I have a copy here. Mine says non-negotiable affidavit of
good.
fact.
Well, I'm not the one that filed this, so I'm not the one that put it in. But in any event, there is no proper application before this court. There is no unorthodox application before this court. This court, according to your statement, lacks jurisdiction to determine its own jurisdiction, and absent a proper application, it's never going to happen.
Objection, ma'am. I haven't stated for my own opinion. Again, courts enforcing their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, because obviously this isn't a court of law, do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. Boswell versus Otis, 9-How.336-348 to wit. You want to take a look at that? I don't know.
No, sir, I don't want to look at it. I don't want to look at it.
I'm asking.
Sir, you don't get to talk to him. You can talk to me if you want. Well, in any event,
I'm
let me know.
with him standing there, man.
That's too bad.
Well,
He's going to remain standing there until I tell him
And
otherwise.
this is threat, arrest, and coercion. It's clear that this is a colorful court of law. Excuse
But
me.
it's colorful. If you look around, it is colorful.
Well,
Oh, colorful. I thought you said colorful.
Oh, no, I didn't say that, man. I said colorful.
Okay, colorable.
Yes, de
I thought you
facto.
said colorful.
De facto.
Mm.
Colorable means that this court has no jurisdiction and it doesn't enforce law, but mere statutes, which are not law. I haven't violated any constitutional laws. I already stated for the record that I have a treaty of peace and friendship via 1787. Article 4 of that signifies that I will have the right to be exempt from examination. No one in here has put their status and nationality on the record. The U.S. flag is behind you, and you choose to disregard anything dealing with the Constitution. This is a colorable court of law. The notice of removal has already been filed, so whatever takes place here today is just a colorable de facto proceeding, and you will be receiving shortly the notice of removal. And then when you receive that, you can make your determinations about how you're going to handle that and how the prosecution is going to handle that. But as far as any other question goes, man, I'm not obligated to answer them. I shall not be answering them. And it is a violation of my rights.
Are you finished speaking so that I can speak now?
You can fill one out.
Again, I am satisfied from what little Cheyenne Mutada Kushamirel has said that he lacks the present ability since his job is uplifting fallen humanity and the only compensation he receives is the grace of God, and I find that he lacks the present ability to obtain counsel to represent himself. If in fact, however, this matter is going to be removed to federal court, I don't have a copy of the notice of removal, so I don't know what the status of it is. We, of course, will take no further action in this court. I'm not aware of it being filed, but I take from Cheyenne Mutada Kushamirel's word that something was filed with the federal court that purports to be a notice of removal. If it's the same as the kinds of things that get filed with me, I'm not sure it's ever going to happen, but we'll do that. But in any event, what I will do is, there are several things that I want to do today. I know that your office needs some time, and I do have a copy of the non-negotiable affidavit of fact, which I will make available to you.
Love her.
And we'll give you the first thing that I want to do is this. In this matter, which is under docket number or indictment number 08-04-0441, there are two named defendants. There is Cheyenne Mutada Kushamirel.
Objection, man. This is Mutoda.
Mutoda?
I don't understand about your phonetics. Mutoda.
Mutoda?
Mutada.
I thought you had told me it was M-U-T-A-T-A.
No, M-U-T-O-T-A.
I stand corrected. Cheyenne Mutoda Kushamirel.
Precisely.
And the other person named in this is Nobel Amir KCL. And I am going to, sua sponte, sever these matters. so that there are it will no longer track as one case, but will track as two separate cases, so that I can list them on separate days and deal with them separately.
That's called divide and conquer. These more sovereigns don't have a chance.
Let's see. March 23rd, sufficient time, Mr. Walker?
I think so, Judge.
All right. Then this matter shall be and hereby is continued until Monday, March 23rd at 9 o'clock.
Objection, ma'am. The notice of removal is already in. You will be receiving it today. So
If I receive it before March 23rd at 9 a.m., I am aware of my obligations when a matter has been removed to federal court. If for some reason the federal court does not accept it, or it's not properly filed, or there's something else, that's the next date for this proceeding.
objection,
Thank you very
ma'am. I will
much.
not be participating in any more of these proceedings.
Do what you want.
I'm sorry, I can do that.
This is the only notice that I will give you of the proceeding on March 23rd at 9 o'clock in the morning. We don't send out letters reminding people. We simply expect that you will be here. Thank you very much.
Be contacted by my office, and we'll arrange an interview in the office, and they'll have to sign that.
Do you have his address?
The
It's on here.
address I have is
The P.O. box is right here.
Objection. If you attempt to contact me and negotiate any contracts with me, you will be being sued in federal court too as well, sir.
All right. Thank you very much.
Oh, what an idiot.
Okay, so now here we have the Morris co-defendant.
Oh, then we're going to...
Objection. Mr. Keesley is not here on behalf of me. He's here on behalf of your interest. When I first visited this percentage, the first time we met, man, you stated for the record that you were Mr. Keystone on this matter. And this matter was
I
charged.
was what?
You were placing Mr. Keystone on this matter. This matter, Mr. Keystone is not on this
Judge
matter.
Smith did that.
No, Judge Smith did not do that. In fact, when we first addressed this matter, no, I'm talking, excuse me. When we first addressed this matter, you read on the record, and I have the video, that you did not understand what Judge Smith meant by that this matter was to be adjourned until the defense inquired representation. That's what you said, man. Mr. Keesler was not on this matter when it came there, man. So therefore, he's not on this matter now. I do not require the services of the Office of Public Defense. And if he was on this matter, there's never been an interview. There's never been any discovery forwarded. There's never been an indictment forwarded. We don't have any copies of the official state of New Jersey certified Essex County public records that were stolen by Matthew T. Dill and are unlawfully held by the Office of Prosecution. We don't have copies of that pursuant to the courtroom rules that I've heard you mention plenty of times that stipulate that we're supposed to be given copies of those instruments, or those original instruments ought to be transferred back so they're not contraband, or issued in the indictment, or listed in
I
the
wouldn't be
indictment.
saying that, but
So I don't have any information relative to this matter, ma'am. So the account numbers that you read, I don't have any information pertaining to them.
thank you, sir.
Hey, Judge, if I could just clarify the record. In proceedings that took place downstairs before Judge Smith, he had removed the Office of Public Defender from Representative Mr. L. He then later reversed that ruling and sent the matter upstairs to Your Honor. So, as a point of clarification, when we came up here, you had indicated that, given the fact that Judge Smith had reversed that, or that the Public Defender's Office was in this matter.
All right, thank you for refreshing my recollection.
Now, sir, I'm talking.
Look, it's not the case.
Well, I'm talking.
Objection.
Please, ma'am.
He is
Here,
not my
Amir
attorney.
ACL.
No.
He may not be
Not Nobel. Not Nobel.
Amir
No.
ACL. Mr. Kiesler is speaking to the court. Whether he's speaking on your behalf or on his own behalf, please extend to him the courtesy that has been extended to you and let him finish speaking.
No
You
problem. I
will
just
have
want him to
the
clarify.
opportunity to respond. Please listen.
No problem, man. I just want him to clarify who he's speaking on behalf of before he makes a
He
statement.
doesn't have to respond to anything that you say. He's speaking to me. Thank you, sir.
That brings us to our next point. Quite frankly, Judge, we need to make a motion from our office to be relieved for non-cooperation. When we were representing Mr. L, Judge, we had forwarded information on Mr. L was returned to us, Judge. There's no communication between us.
Did you send it to the post office box address?
You sent it to multiple addresses, Judge.
Objection, man.
Given the fact that it's clear, Judge, he stated numerous times he doesn't want us to represent him. He will not cooperate with us, Judge. We can't effectively represent someone who does not want us. So if Your Honor requires a formal written motion, I can have that filed by the end of the week. But realistically, Judge, we're asking to be relieved for non-cooperation.
Objection, man. I wish that.
What is your objection? And
I'm
what are your
objecting to the
objections?
fact that there hasn't been any information forwarded to my office's P.O. box.
So this is how ridiculous these Morris sovereigns are. This Morris sovereign clearly doesn't want this public defender to represent him. This public defender just stated his case with the judge, pretty much asking for the judge to relieve him because he does not want to represent this Morris sovereign. So in essence, he's trying to give the Morris sovereign what he wants, because this Morris sovereign doesn't want the public defender. And this fool is going to sit up here and make an objection. Like, this is how clouded these Morris sovereigns' brains are. Your public defender is pretty much trying to quit on you, which is the outcome you want, and you are still being argumentative with the judge about it. This is counterproductive. This literally makes no sense. He is trying to give you what you've been asking for. You don't want counsel, and he is trying to give that to you. He's stating to the judge, like, please, judge, get me away from this guy. I do not want to represent him. And this fool is still objecting to everything. It's like he doesn't, his ears aren't open. It's almost as if he has earplugs in his ears. Like, he must not have heard anything that this lawyer has just said, because why would you object? Like, this is ridiculous.
I'll put that information on record, Judge Smith. I'll receive the recusal notice. No problem. All right. Now, if the Office of Public Defense or anybody, prosecution, whoever stipulates that, they forward the information to our P.O. box, that's a lie. And we ask for them to present proof of receipt or proof of sent of the correspondence.
Can I ask you a question? Can I ask you a question? One of the things that you say is that you've never received a copy of the indictment.
Exactly.
Which indictment are you referring to? All three of them?
In whatever information that you have on your desk, I don't have anything.
I can resolve that problem right now. Mr. Kramer. I need you to make a copy of something for me. I don't have the old 0302, so I'll make copies of the ones that I do have. Okay. And there's another one. Your copy machine. Okay.
As well, I don't have.
No, please, sir, please. I'm looking through the file. I can't listen to you and also look through the file at the same time.
Alert, she's trying to give you what you want. Shut up and stop tripping over yourself.
If you could make one copy of each of these and bring them back to me. Thanks.
Man, while he's at it,
hold on just a second here.
There's also other information that I'm addressing that he may want to copy. pursuant to Rule 313, 3-3, Discovery and Inspection Rule, the prosecutor shall permit defendant to inspect.
May I interrupt you for a moment, please?
No,
May I interrupt you for a moment, please?
No, man.
All right, you let me know when you're done.
For the record. For the record.
All right, the record shall.
Bottom line is,
The name of ACL is placing the information on the record.
all right, the bottom line is, pursuant to your courtroom rule 313, 3-3, B and C, I believe, I'm not part of the society, so I'm not 100% familiar with it. But
Some of it may be unintelligible to you,
according to it, I'm not familiar with it.
but I understand.
So, just correct me if I'm wrong, but
You're wrong.
it stipulates that, Discovery and Inspection Rule 3:13, 3-3B and C, it stipulates the prosecutor shall permit the defendant, if you're claiming I'm a defendant, I've been here almost 8 visits, and this prosecution has failed to prove jurisdiction, and so you. It stipulates that books, counsel, objects, papers, and documents obtained from or belonging to the defendant, records of statements or confessions, signed or unsigned by the defendant, or copies thereof, in a summary ready admission of declarations against penal interest made by the defendant that are known to the prosecution but not recorded, books, papers, documents, etc. I'm supposed to be given a copy of that, if not the originals. Those documents are not considered contraband or are not listed in any of the indictments that you may have before you. So I'm either requesting for the return of the original certified documents, the public records that were taken, or copies of those documents according to the rule, which says I have a right to have. I'm also going to address.
I like that. He's so smug he thinks he won with that one remark.
I believe a week ago, he stipulated that today's matter will be relative to jurisdiction, your jurisdiction or the prosecutor's authority of jurisdiction. You have no jurisdiction, and neither does the prosecution, Arlington County, the state of New Jersey, or the United States. So I'm letting you know that now, and I'm asserting that I'm protected by the Treaty of Peace and Friendship via 1787 pursuant to Article 4. You must dismiss this case.
Wrong.
Thank you, Trump.
Sorry to burst your bubble, Bob, but the Treaty of Peace and Friendship has nothing to do with you, nor will it help you with this case.
You have no jurisdiction, and neither does the prosecution, Arlington County, the state of New Jersey, or the United States. So I'm letting you know that now, and I'm asserting that I'm protected by the Treaty of Peace and Friendship via 1787 pursuant to Article 4. You must dismiss this case. For the record, on the record, let the record show.
Not the record, not up by the record.
Not my obligation is do not point.
Yes, you have a constitutional oath to uphold the Constitution, man.
You misunderstand the procedure. I will attempt to explain it to you.
Objection.
The documents that you want are not documents that are in the court's file at this point in time.
Objection,
I don't know
ma'am.
if they would ever be in the court's file at this point in time. If your position
that's
is,
not my problem, man.
if you absolutely it's your problem. If your position is that you want them from the prosecutor and you have requested them from the prosecutor,
That's right.
and the prosecutor has failed to give them to you,
That's right.
you can make the appropriate application to the court, and you can say to the court, I've asked for them, I'm entitled to them, I haven't gotten them, order them to give it to me.
I've already
I have
filed
received
a notarized affidavit of fact in reference to return of property weeks ago. A notarized affidavit. So if you're telling me you don't have to acknowledge affidavits, all right, that's what your statement is. However, bottom line is this court has failed to prove jurisdiction and has avoided the issue of jurisdiction at all costs. And nobody in here has the status. All right? Nobody has proven status, and nobody in here has the authority to proceed. Now, the last hearing we discussed, you stated that
Could you please stop yelling at me?
this matter, you stated, ma'am, for the record, you stated that this matter was relative to jurisdiction, not Mr. Keesler's position here, and not anything else. You stated that you were giving the prosecution a chance to prove jurisdiction. And he's not even the assigned prosecutor to the case, but obviously he's remaining silent, and he has nothing to state. So I move that this case be dismissed.
When there is an appropriate application before this court to address the issue of discovery violations, jurisdiction, or anything else, the court will act. Filing a notarized or not notarized affidavit is not an appropriate way to bring a matter before the attention of the court. What you must file is a notice of motion. It sets forth the relief that you want, and it needs to be supported with a certification, an affidavit, whatever it is.
Can you repeat that, ma'am?
Notice of motion. This is exactly what I told Cheyenne Matoda Kushmir L.
For the record, man, which rule, authority, courtroom rule, statute are you using?
It's in the court rules. I do not recall. It is in the court rules. I do not recall, and I'm not going to look up for you the exact court rule, but the court rules set out the procedure that you must follow.
Objection, ma'am. I'm not a part of your society. I'm not subject to your courtroom rules, and you have not proven jurisdiction.
And I will never address the issue of jurisdiction until and unless the appropriate application is made before the court, because filing either an affidavit that's notarized or an affidavit that's not notarized does not bring it before the attention of this court.
Now, the crazy thing here is that he's filing all of this paperwork in the wrong way. So the judge is pretty much trying to tell him how to file it in the correct way. And what he is trying to do is bring up the issue of jurisdiction. So he done been to court 8 times saying the same things over and over and over with the jurisdiction, when in reality, even if he does file the paperwork in the correct way, all the judge is going to come back and say is, sorry, sir, the courts do have jurisdiction over you. So this man is just wasting his time making these arguments and filing paperwork the wrong way, because the answer is still going to come back not in his favor. The answer will come back, sorry, sir, the courts do have jurisdiction over you. Now move on.
Objection. There is no discretion to ignore lack of jurisdiction. Choice versus United States. Jurisdiction is fundamental, and the judgment rendered by a court that does not have jurisdiction here is void ab initio, and that is application of Y300 P.132 versus Caveat. Once jurisdiction is challenged, the court cannot proceed when it clearly appears the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action. Melo versus United States 505 F2D. When jurisdiction is challenged, the party involved jurisdiction has the burden of establishing. Basso versus U.S. Power Light Company. Court enforcement statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not obtain jurisdiction by service of process, nor even arrest, and compelled appearance. I'm here by way of threat, duress, coercion. I'm going to make that clear for the record every time I have to appear here, if I have to appear here. The only reason I'm appearing here is by way of your threat, duress, coercion, or your company's threat, duress, coercion.
You can read me, let me interrupt you, please. You can read me this until the cows come home. You can read it ad nauseum and ad infinitum. It doesn't change the fact that until the issue is brought appropriately before this court, no ruling with regard to jurisdiction is ever going to be made. Now, let me ask you this question, though. In the other matter, first of all, let me backtrack a little bit. Let me get the correct number out here, because we now have 2 numbers. In the case with indictment number 08-04-0441, which is the one in which Cheyenne M. Cushing-Murrell is also involved, I have severed those matters, so they will be on completely separate tracks. But he told me that he had filed a notice of removal to the federal court, and my question to you is, have you filed a notice of removal to federal court with regard to any of these matters?
Yes, ma'am. Notice of removal
All
has
of
been
them?
filed
All of them?
regarding all
The
matters.
three matters?
Yes, the three matters that
Can I ask you, please, if you tell me, when did you file this?
it was filed last night. FedEx.
To the federal court?
To the federal
All
court.
right.
Yes.
Well, as I am sure you are aware, if the court accepts them, then we will simply transfer them to the federal court. We won't deal with them anymore.
Okay, well, I'm still sure you're aware of the matter that you've not proven jurisdiction in either of the hearings and that you avoided addressing the issue of jurisdiction.
And I will continue to not address the issue of jurisdiction until the appropriate motion is filed with the court and the court has the ability to address it and make a determination with regard to it.
And Judge, if I could just for a minute, that's the issue at hand. As currently stands, we are representing.
Objection. You're not representing the issue.
Therefore, it would be our responsibility to file that motion. Given the fact that he will not cooperate with our office, it's impossible for us to do that.
Objection.
We really need to
Now,
reach the issue.
I want to get back to what I do want to get back to what Amir KCL said. Now, we addressed the issue to some extent with regard to the indictments. I have here for you, and the record will reflect, that I am giving you a copy of the indictment that has 08-07-0727 and also 08-04-0441.
Objection. Just for the record, the Office of Criminal Defense is not representing me. You don't have any power of attorney for me, and I'm not part of your society, so you cannot represent me, and we do not share nationalities. Okay, now, for the record,
Mr.
I need the
Kramer.
nationality of every agent in here, and I need the name and the information, because I'm suing everybody.
Mr. Kramer.
Everybody. So I need everybody's name and your position, starting with you, sir.
Who is calling out from the audience?
I was, man.
No, you were not.
Yeah, like it. No, you're
No,
not.
do not hand anything over. Nothing. In the audience, please do not call out while court is in session, or the officer will ask you to leave. These are now completely discombobulated. They're not stable. Well,
The one wasn't stable. The one was. Wasn't stable. Which one was that?
no, I don't have look, you can't even read this. Is that what I gave you?
I think so, yeah. I give you that for you. You have copies. Yeah. I give you that.
I need your name and position, sir. I need your name and position, sir.
No one is going to give you any information.
Ma'am, are you stating that you are not obligated to provide me with your identity and status?
You know my name.
Your employees or your co-workers are not obligated to provide me with their identity, status, and company position, ma'am? Ma'am,
Yes?
did you not just hear me?
I didn't hear you. I'm sorry. I was trying to get the paperwork together.
Okay.
Can you wait a moment until I'm finished?
No, I'm going to repeat myself. I'm here on the time, man.
Hold on. I'm trying to get all these papers together.
So it's a simple question. I'm sure you can answer it while you get your papers together.
I cannot get them together. I can't. This only has 3. Okay. This has 3 counts, and this you didn't make a copy of the last count. So make a copy of the last page and bring it in, and we'll staple them together. All right, Noble Amir KCL. You complained about discovery. I think I've addressed that. I'm giving you the copies of the indictments, and you said you've never been interviewed. I am sure that Mr. Kiesler can give you now a date for you to be interviewed.
Objection, ma'am. I do not require the Office of Public Defense or any attorney at law.
But you told me that you were complaining that you hadn't been interviewed.
No, what I stated was, if he was representation on this case, he has not provided assistance. If he was representation for this case, the assistance is ineffective.
Well, my understanding is that Judge Smith has required Mr. Kiesler to represent you.
Objection. I'll address this matter with Judge Smith. Judge Smith does not have jurisdiction and could not prove jurisdiction. Therefore, Judge Smith does not have the authority to make any decisions for me. And neither do you. And neither does Mr. Kiesler, and neither does the Office of Public Defense. For the record. Now, as I stated, you just told me that you did not hear my question. My question was, I need the information for the people here who are attempting to force business on me. I want his name and position, I want her name and position, and I want his name and position.
I
And I
have
want
asked
your
you
nationality.
before not to point at me, and I am now going to ask you not to point at anyone else in the courtroom. It is very impolite.
No problem, man. Now I'm asking
You
you to
know
answer
my
my
name.
question.
You know my name. That is all you need to know.
I don't know your name, man.
Judge Levon. That is my name.
Your nationality?
You have no need to know my name.
Yes, I do. You are attempting to force business upon me. I need to know your nationality. For the record. And your status. For the record. And anybody else that's working with
Your
you.
questions are unintelligible to me.
This judge is straight up schooling this Morris Salvo. It's like you sitting up here asking these stupid questions that have nothing to do with anything. Even if you did know her nationality, that is not going to help you out of this court case. And for the record, her nationality is American. And that's why she isn't answering the question, because you're asking stupid questions that have no relevance to this case.
And with that, we will leave you for this evening because, well, we got to. So I guess we will have one more day with the Moors as we will finish this case to its conclusion, thank God, tomorrow. So as we do one final fight, of course, make sure you do like, share, and subscribe. Get us to those goals of 50,000 viewers, 1,000 subscribers. So Boxing Extras will send us those nice red shiny boxes, and Google YouTube will pay attention to us and send us items so we can send to you as well. Coinbase and Ibotta are below. Fill them out. You'll get $10 free to use whichever way you like. And of course, Coinbase will let you do Coinbase and Earn, less than 2-minute lessons, one question quiz, in order to get up to $100 in free crypto to use here in Dominion, or anywhere else you'd like to use it. And Ibotta will reward you for what you normally need to do anyway, and that's, of course, shop. So until we do meet again for our bell in the overnight period, make sure you do like, share, and subscribe. Be kind to one another, because again, in this world, when it all boils down, it's all we have is each other. May your fights in Dominion always be awesome, and what items you need drops for you. And it's a great new world to release the crackheads. We'll see each other during the overnight for our bell. Until then, continue to march along here from day one. Have a great evening, everybody.